morning. Please be seated. We're here for oral argument in one CR 19-0052, State of Arizona versus Richard Luzania. Judge Campbell will participate in the decision of this case, but she is ill this morning, so she is not participating with us. She's probably home watching this on our live stream video. That wasn't a plug. I'm just telling you that's probably what's going to happen. The parties are reminded you have 20 minutes per side to present your argument. Appellate's counsel, you're advised that you have to reserve any amount of that time on your own to determine if you want to have time for a response. We've read the briefs and have discussed this case this morning in conference. We've gotten comments from Judge Campbell as well. Counsel, you may proceed.
Good morning. My name is Grace Geis-White. I am an attorney with the Maricopa County Office of the Legal Advocate, and I am here today on behalf of the appellant, Richard Luzania. The Ninth Circuit, District of Arizona, Arizona Supreme Court, and the Attorney General's Office agree that the offense of conspiracy to commit first-degree murder is a specific intent crime that requires the state to prove that the defendant had an intent to kill or an intent to promote and aid in a killing, and made an agreement to kill. This was not the instruction provided to Richard's jury. Instead, Richard's jury was told that it was sufficient to convict Richard of conspiracy to commit first-degree murder if they found that Richard intended to engage in certain conduct, made an agreement to engage in that conduct, and that conduct constituted a crime. The Attorney General's Office concedes that this was insufficient and was error. This was fundamental error. And this was fundamental error for three different reasons. First, as discussed primarily in the Evanchek line of cases, when a trial judge omits the essential elements of a crime, that constitutes fundamental error. And that comes from United States v. Gowden, the 1995 United States Supreme Court case. Here, the jury was never told of the essential elements of intent to kill and agreement to kill.
Can't we look to the arguments of counsel to clarify an unclear instruction?
So jumping to that prejudice prong under Escalante, reviewing the arguments of counsel, one mistake I think in terms of reviewing the Attorney General's argument is that we're not instructed to only review portions of the closing. We're instructed to review all of the closing. And so to start with issues with the state's closing, often the state would say in their closing, they conspired to commit murder. Well, the state, in the transcript, and it starts back on page 72 of the October 22nd, 2018 transcript, tells the jury in the beginning of their closing, there are two ways to commit first-degree murder. There are two different definitions of first-degree murder. So every time the state says conspires to murder, this is not clarified by what they mean, because they have told the jury repeatedly there are two different ways to commit first-degree murder, felony murder and premeditated murder. But also, if we move on then to the defense closing, the defense's theory of defense is relevant to the prejudice prong of Escalante, and the theory of defense was heat of passion. Specifically, and the state repeats the theory of defense in their rebuttal, the entire defense argument that there was that there was no premeditation. And so that has to be considered in terms of just because there are points in the state's closing where they say conspired to murder, which again I don't think clarified the issue. We also have to look at the theory of defense. And that actually comes from this court in State v. James, this 2013 opinion from this court, and State v. Felix, the 2015 opinion out of this court, where both of those times, under a fundamental prejudicial error review of jury instructions, this court looked at the fact that the state's arguments in those cases did not implicate the erroneous jury instruction.
We look not only to the arguments of counsel, but the evidence presented. And the evidence presented clearly would suggest a premeditated crime. So if we're looking at fundamental error, we're looking at error that goes beyond just, oh, I asked for an instruction, I didn't get it. if we take into assessment all of the facts and the argument of counsel, why isn't it just harmless?
So again, to reference this court's opinion in State v. Felix in 2015, this court made it very clear that when we're reviewing prejudice, it's not a sufficiency of the evidence test. Evanchek made that clear too, that this is not a sufficiency of the evidence test. And so to first respond to that, we look to what the jury in this case actually found.
And if the jurors had unanimously found premeditated, would you agree that the error is harmless?
Yes, I would not be in front of you now because State v. Anderson, our Arizona Supreme Court case, made that clear. But also, Evanchek itself said if all we were looking at was premeditated murder, then we could assume that the jury considered premeditated murder when they looked at that instruction. But because here we have a jury verdict that says only 10 jurors of 12 found premeditated murder, we have the question of 2 jurors who did not find premeditated murder and therefore also, if properly instructed, could have found differently under the intent to kill and agreement to kill under conspiracy to commit felony murder. So we start there. And just a quick clarification, I know I focused on my reply brief, but when I went back through the record on appeal, and 264 on the record of appeal is the trial prosecutor's sentencing memorandum, and she tells the court this was not a unanimous finding of premeditation. She repeats that at the actual sentencing, and the judge repeats it at sentencing when he recognizes that he can sentence Richard to either natural life or life with the possibility of parole after 25 calendar years, which would not have been a sentencing option under ARS 13-752A if Richard had been convicted of premeditated murder. So the only party that has ever reviewed this verdict and argued anything other than this was not a unanimous finding is in fact the Attorney General. But what we look at is that 2 jurors did not find premeditated murder. So starting there, we can presume those 2 jurors.
Well, let's talk about that verdict form for a minute. Did the jurors follow the instructions as it relates to that verdict form?
Well, they were provided 2 different types of instructions because the state also told them that there was a way to fill out the verdict form. And so ultimately, they followed the instructions to a T when it came to the premeditated murder and felony murder prongs because it said, how many of you found premeditated murder? Out of 12, 10 they wrote down the number 10. And then again, mathematically, when we look at the next prong of how many of you found both premeditated and felony murder, they write 10. And that indicates that there are 2 jurors who did not find the state carried its burden beyond a reasonable doubt. The trial prosecutor,
as it related to premeditated murder.
As it related to premeditated murder. But due to the erroneous instruction on conspiracy to commit first-degree murder, the verdict could have been different if they had known that they also had to find an intent to kill or premeditation before convicting Richard of that count 7. Going back to your sufficiency of evidence, what the record shows, Evanchek, I think, is very instructive on this case. And one clarification I'd like to make is in footnote 4 of the Attorney General's brief, they indicate that Evanchek is not very instructive because it was a harmless error review. But that is a misreading of the standard used in Evanchek 2, the Ninth Circuit. Evanchek, just like Richard's case, dealt with an erroneous conspiracy to commit first-degree murder instruction. His state PCR counsel was the first counsel to find the issue and raised a PCR petition alleging that his trial counsel had been ineffective for not objecting, just like Richard's trial counsel did not object. By the time it made it to the Ninth Circuit was reviewing that case under the Anti-Terrorism and Effective Death Penalty Act of 1996, which is extremely deferential to state courts, required Evanchek to himself prove actual prejudice. And the language used in Evanchek 2 actually indicates they were using the verdict would have been different standard, which is the harsher threshold that the Arizona Supreme Court rejected in Escalante. And so Evanchek is actually very instructive on the prejudice here. And one thing that Evanchek does is it says, we don't disagree that there is a lot of information in this record that supports intent to kill. Evanchek was beat up by the victim before he killed him. Evanchek told the victim he was coming to kill him. Evanchek told the victim's family he was coming to kill him. But then the Ninth Circuit said, but that's not where the test ends. We look at what the verdict forms show, we look at what the theory of defense was, and ultimately they found there was prejudice. The same applies here. The record was disputed in parts. During the closing of the defense points out that they don't know if it's premeditation based on the gunshots because there was no blood splatter testimony. No one ever testified to there being blood splatter on Richard or his co-defendant. There was also a dispute about the door because law enforcement actually testified that there was no indication that the door had actually been kicked open. And because of where the bodies were actually located, there's also evidence that Richard did not go in shooting, that there was some sort of altercation, and in fact, the state calls it a confrontation at one point, before the killings actually occur. And so there was also a portion of the record that supports a finding that Richard was guilty of only committing burglary or kidnapping, and in the course of that, he ended up killing AG and FV. And I think one of the cases that is instructive on this is, again, State v. Felix, this court's 2015 opinion, and that was where the defendant got beat up, returned to the house with an AK-47, and shot numerous rounds into a house containing multiple people, and was charged with 10 degrees of attempted murder. But the jury acquitted him of first-degree murder and found him only guilty of second-degree murder, which the instruction had erroneously said that they could convict of attempted second-degree murder if they found only serious physical injury, intent to cause serious physical injury. And so this court looked and said, well, yes, obviously the record supports a finding when someone shoots into a home with an AK-47 that there was an intent to kill. However, the record also supported a finding that the jury could have found all that this defendant intended was to cause serious physical injury to the occupants of the house. And so because the record supported both, the verdict could have been different, and the error was fundamental and prejudicial. It's the same here. There's two readings of the record, but the one part of the record that supports a finding of only felony murder, which again is bolstered by the fact that two jurors did not find premeditated murder, supports that this was fundamental prejudicial error and the verdict could have been different. Returning again to the fundamental portion of the error, there is the third discussion about what constitutes fundamental prejudicial error, and it's applicable here in that it occurs when a trial judge instructs the jury on a non-existent theory of liability. And so here, as in Evanchek, as in State v. Felix, State v. James, here the trial court, because the instruction was incorrect, the generic conspiracy instruction was incorrect under these circumstances, the jury was essentially told that they could find Richard guilty of conspiracy to commit first-degree murder if all they found was that he had intended to commit felony murder. And so Evanchek, too, I think, illustrates it the best when they say all it would take would be one juror deciding that all the defendant intended was to commit burglary or kidnapping, and in the course of that conduct ended up killing somebody, resting that conspiracy to commit first-degree murder on that conduct. All it would take is one, and that would mean that the jury had not unanimously found intent to kill and agreement to kill, which are essential elements of conspiracy to commit first-degree murder. In sum, the reason that this is one of those rare cases that warrants fundamental error review is that the jury was never told the correct elements of conspiracy to commit first-degree murder. Going back to this court's State v. James 2013 case, there the court recognized that at least when the indictment was read to the jury in the beginning of that case, the indictment included the correct mens rea. Here, and even in that case, this court ended up finding fundamental prejudicial error. But here, if you go back to the record of appeal, number 6 is the indictment. The indictment contained the wrong language. It contained the certain conduct language. So the jury, in the beginning of the case, was told the wrong elements, then was orally read the wrong elements by the trial judge, then was given them in writing, and again, distinguishing this case from other cases where this court has found fundamental prejudicial error, the state then twice in a PowerPoint presentation put them up for the jury to read. And it's slides 9 and 10, and one immediately follows the instruction on felony murder. So the state also instructed them in writing on a PowerPoint the wrong elements. And so if we look at our Arizona Supreme Court's line of cases, including State v. Payne, their 2013 case, instructions that we presume jurors follow the instructions, the only instructions that this jury was ever provided were wrong. Given that, this case does not require imaginative guesswork. This is a case where the jury never knew that in order to convict Richard of count 7, They first had to find that he intended to kill the victims and that he made an agreement to kill the victims. Given that, I ask this court to find that this was in fact fundamental prejudicial error and reverse on count 7. If there are no other questions, I will reserve my time for rebuttal.
Thank you, counsel. Mr. Maziarz.
May it please the court, Joe Maziarz from the Attorney General's office representing the state. This case really comes down to a simple question, and that is, does fundamental error review really mean anything? Both parties agree that the conspiracy to commit first-degree murder instruction was deficient. Of course, it would have been easily remedied had Luzania's counsel, and he had 2 of them, I might add, found any problem with their theory of defense or that in any way this prevented him from presenting his defense. And his defense, I might add, was not that it was not premeditated. It was, 1, I left, I didn't do it, and 2, if I did, it was self-defense. He wasn't defending on the basis I committed maybe felony murder but not premeditated murder. That was not his defense.
But that certainly is a I didn't premeditate defense.
Well, I think it's a I didn't do it defense, and it's a self-defense defense, because self-defense essentially is, in a way, premeditation, because, I thought about it and I had to do it to defend myself.
Could you explain your theory that we can somehow read the verdict to conclude that 12 jurors found premeditation?
We don't know, and the reason is, and I think Judge McMurdy touched upon this, is, and this is notorious over the years, that when you give these interrogatories on first-degree murder, the jurors are essentially instructed that you find either premeditated murder, felony murder, or both. And here we have 10 finding premeditated, 12 finding felony, and 10 finding both. And I think in my brief I put 22. My math wasn't very good. That really comes out to 32. So we really don't know precisely.
It seems pretty apparent at first blush to me that 10 of them found premeditation. All of them agreed there's felony murder, but the 10 that agreed on only 10 agreed on premeditation. So there's only 10 that agree that it was both premeditated and felony murder.
Well, the way I read the court's instruction, and I'll admit this isn't the best interrogatory or instruction, the way I read the court's instruction to the jurors is you decide either premeditated murder only, felony murder only, or both. And again, we have 10, 12, 10.
But what do we do with, there's a number 10. Doesn't...
Well, and I'm not saying...
clear about that.
Right, I'm not saying that proves that all the jurors found it was premeditated. I'm simply saying it doesn't prove that 2 of them did not find premeditation. What I'm saying is the verdict forms really tell us nothing. And...
Well, hold on, because in looking at that verdict form, under what theory do we get to say there weren't at least 2 that didn't find premeditation?
Because the 10 at the bottom finding both, 2 of those may have actually followed the instruction and not voted premeditation only, but voted premeditation and felony murder.
But there was a 12 on premeditation.
There was 12 on felony.
12 on felony, okay.
Right. And again, I'm just saying, I don't think that, and I'm not relying on that to prove that 2 others found premeditation. I'm not relying on that. I'm simply saying that the verdict forms really tell us nothing.
Let's say it was a simple verdict form and it just said 10 jurors found premeditation, but 12 found felony murder. There's no additional combination. Would you agree that the error is not harmless? If 2 jurors specifically said there was no premeditation, how do you conspire without premeditating?
Right, and that was my second argument, is even if we take as a given that only 10 found premeditation, that's still, and we've got to bear in mind that the defendant, Luzania, bears the burden of proving not only error, which we concede, but also that it's fundamental and prejudicial. And he would not meet that burden for the reason that the closing arguments of counsel make it crystal clear to the jurors that they had to find an intent to kill. And in his closing...
But we have a verdict, and I guess I completely agree with that. Usually we look to the closing argument, and if it clarifies an unclear instruction,
And that's what
problem is
Escalante
solved.
and other cases
Right.
tell us.
But where we have, if all we have is a verdict form where two jurors say you did not premeditate, what is it about? How do you conspire to kill somebody without premeditating the murder?
You really don't, and that's what Ivanchuk points out. And let me answer your question on why two may have not actually decided premeditation. And the answer is really simple. This is not a situation where any of the jurors even have to look at premeditation. There's not an acquit first. There's not a best efforts. They're simply told you find one or the other or both. Once they found burglary or kidnapping in this case, it was clearly felony murder. There was no need to grapple with the one-page long instruction on premeditation.
Well, and that seems like it'd be a good argument if we only had a verdict that said 12 people agree on felony murder. We could still find that they also conspired to kill because there was, but where we have a verdict form that says only 10 believe there was premeditation.
But that verdict form went to first-degree murder. It didn't go to conspiracy. And the reason, and quite frankly, the reason I had assigned this case to myself was I envisioned filing a concession of error. But after reading the transcripts, and particularly the arguments of counsel, I didn't feel I had a good faith basis to concede that Luzania proved that the error was fundamental and prejudicial. And again, when you look at the arguments of counsel, in his closing argument, Luzania counsel says, did Richard Luzania go over there with the intent to murder Alexis? Did he conspire and plan to go over there and murder Alexis? Because that's what the state is telling you. That's what they are saying the evidence shows. That he conspired with Christian Arguelles to go over there and murder Fabian and Alexis. And then the state specifically says, conspiracy. The defendant and Christian Arguelles working together to go over there to that apartment to kill Fabian and Alexis. And the jurors are also instructed that the arguments of counsel can assist them in understanding the instructions. When you have both parties agreeing that there must be a plan and intent to kill, I simply don't see how the defendant can ever carry the burden of proving, one, that the error is fundamental, and especially that it's prejudicial under the facts of this case. The evidence also strongly indicates, and I'm not saying it's dispositive, but it strongly indicates an intent to kill. In my 35 years, I've never seen a case where tape is brought to cover the peepholes of
But isn't the tape because she wasn't letting him in, regardless what his intention? I'm not sure that.
Well,
shows
and I
that
agree it's
an
not
intent to murder.
dispositive, but I think it's strong evidence that there was something more than merely going over there to rough up Fabian. That to go to the lengths to take tape to cover the peephole, not only of the victim's apartment, but the apartment across the way, indicates that they had something serious in mind. The fact that they brought a gun, the fact that they shot the victims 10 times.
Burglary, felony murder is certainly serious. I'm still not sure that shows we're going to go into murder and we're premeditating murder.
And I prefaced it by saying I'm not saying it's dispositive. I'm simply saying, in addition, I think the real dispositive issue here is the closing arguments of counsel, along with the court's instruction that the arguments can assist you in understanding the law. I think that really, in a nutshell, negates any, and again, we got to bear in mind, Luzania bears the burden of proving that it's fundamental error and prejudicial. And given that argument, I don't see how you can get there. Yes.
Well, the point, the part I'm struggling with is you look at the evidence, and I agree, it looks like there's very substantial evidence of premeditation. I look at the arguments of counsel, and I think, yeah, it kind of looks like they specifically argued an intent to kill. But then I get a verdict form where two jurors didn't find it. And I'm struggling. I realize that we can have inconsistent verdicts in Arizona, but what I struggle with is the notion that we have inconsistent verdicts on a point of law where we all agree there was error in the instruction.
See, I disagree that they're inconsistent because, again, the jurors don't even have to use best efforts to determine whether it's premeditated or not. And the prosecutor in his closing arguments specifically told the jurors, you can decide one, you can decide the other, you can decide both. Don't really waste your time on this. And that's the transcript of October 22nd at 89 to 92. Again, this was a simple case for felony murder on the first-degree verdict because once they find burglary, there was no question the victims were killed during the course of and in furtherance of the burglary. They were shot to death either in or alongside their bed. So there's no finding of a lack of intent to kill. The jurors, if we take as a given that two of them didn't specifically find premeditation, they had no need to even consider premeditation. So I think.
But why fill out that verdict form if you're saying they didn't consider it?
Well, and that's why sometimes the state charges alternative counts in premeditated murder count 1, felony murder count 2, because these interrogatories are inherently difficult for jurors to follow.
But if you do it, it doesn't strike me as being that difficult. I can read it and say, I agree they went in there to commit a burglary. I'm going to convict him of first-degree murder. 10 of the jurors say, I think they went in there intending to kill. It seems, in looking at that verdict form, it doesn't seem confusing to me. That's the way I would read that.
Well,
10 said premeditated, 12 said felony.
We're lawyers, and we understand the definition of premeditation. But if you look at the instruction, it's a page long and gets into reflection and is sufficient. Others just say, well, I don't even need to look at that. I know this is felony murder.
But then don't you leave that blank? I'm not going to look at that. But when you actually put a number down, 10 of us looked at it, we read the instruction on premeditation, and only 10 of us think there was premeditation.
Because 10 of them decided they were going to find both because they had no doubt. The other two, again, if we're assuming the verdict forms mean anything, simply said, I don't even need to decide that. It's clearly felony murder. I don't need to grapple with this premeditation instruction. And the fact of the matter is, while we know that that conspiracy to commit first-degree murder necessarily, as a matter of law, being lawyers, would constitute premeditation, all that's really required is an intent to kill. And Ivanchek makes that crystal clear. We know an intent to kill, if you plan ahead, conspire, constitutes premeditation. But the jurors weren't required to go that far. Again, I think when you look at the arguments of counsel here, it's really dispositive of any claim of fundamental prejudicial error. And the final point I would make is that speculation is not prejudice. Given the arguments of counsel and the evidence, it's speculative in the extreme to believe under these circumstances the jurors didn't find an intent to kill. The Arizona Supreme Court had held that it's a formidable burden to establish that an error is both fundamental and prejudicial, and that it's the rare case where an unobjected to error will result in reversal on appeal, and this is not one of those rare cases. So in conclusion, I would ask the court to affirm not only the other convictions which are not at issue, but also the conviction for conspiracy to commit first-degree murder.
All right. Thank you, counsel.
As an initial point, I think it would be very dangerous to start interpreting jury verdicts that say 10 out of 12 found something to mean anything other than what the jury wrote. We presume they followed the instructions. 10 wrote 10, 2 did not find premeditation. With regard to the premeditation count, it was the first one that the jurors were asked to fill the verdict form out for. And the state did spend most of their closing arguing for premeditated murder. It was definitely the theory that the state thought they had proven beyond a reasonable doubt, and it was the crime that would guarantee a natural life sentence. And the defense was, in fact, lack of premeditation. The state, in their rebuttal closing at 117, actually tells the jury, the defense wants you to believe there's no premeditation. And so I don't think it's a rational reading of the closings to say that this was a purely self-defense argument. There was an argument that this was not premeditated. And in fact, if we start piecemealing out the closings, that's what indicates that this was never, that the closing arguments did not clarify the error, because the state says again in their rebuttal closing that Richard picked Christian up and told him that he was mad. That was the evidence presented about the conversation that Richard and Christian had before they walked into that house, that he was mad. It wasn't that he picked Christian up, said, we're going in shooting. It was that he was mad. And so there's a question of what their intent was. Again, even though the peoples were covered, 2 jurors decided that was in and of itself not evidence of premeditation. The door was open. It was not kicked open. The state even says in their initial closing on page 90, let's assume they didn't go there to kill the victims. Then they go into burglary, armed robbery, and kidnapping. And so every time they are saying conspired to murder, the jury is going back to this idea of, okay, let me think about what murder is. Murder is 2 things in this case: premeditated intent to kill, and then felony murder, intent to engage in burglary or kidnapping, and the victims died. We cannot presume that the juries thought anything else, because that is what the instructions told them to do. It's what the state told them to do. It's what the defense told them to do.
But you're suggesting conspire to murder. I'm going to conspire to go commit a burglary where a death will result. Seems to me the more logical layperson's view of, if you're being told conspire to murder, would be I'm conspiring to go and kill someone.
It would be a rational interpretation of the instructions in this case were correct, but because the jury was told, here's the 2 definitions of what the word murder means in this case, because most lay people don't realize that there is a second felony murder definition, but this jury was told this was the definition. But also then the state twice puts up a PowerPoint of this instruction, which just says certain conduct. And they had just been told that felony murder required certain conduct: burglary, kidnapping, armed robbery. So here, when read all together, it's very unclear as to how the jury would have interpreted that instruction. And if we presume they followed the language of the instruction, then we have to wonder if the verdict could have been different, because they could have assumed, well, he committed burglary and there were deaths, and therefore he conspired to commit murder. That's one form of murder. Just touching briefly on the inconsistent verdicts, Evanchek 2 discusses this in footnote 5, that while we do not presume that inconsistent verdicts are unconstitutional, the whole premise for that assumption is correct jury instructions. Because we're assuming that they are getting the correct jury instructions and that the jury is following those jury instructions, then we allow occasionally for outcomes of inconsistent verdicts. This is not a case of inconsistent verdicts, just like Evanchek was not a case of inconsistent verdicts. And so just as closing in terms of the record, again, Evanchek told the victim he was coming to kill him. Evanchek told his victim's family, I'm coming to kill him. He actually built a headstone for the victim before he killed him. And what the Ninth Circuit said when reviewing our Arizona Supreme Court's decision in Evanchek 1 is that's not the end of the test. Here, the jury was told the wrong instruction every step of the trial. They were never told the correct elements of the case. And then 2 of them found that there was not premeditation. Closings did not alleviate this error. So I ask the court to reverse count 7.
All right. Thank you,
Thank you.
counsel. The matter is deemed submitted. We'll issue a decision in due course after conferring with Judge Campbell. We stand at recess.